the cost of going to an arbitrator by the time you're finished with all the costs inherent in going to a court, including wasted time, is more cost efficient with an arbitrator. But you need an arbitrator who will also be cost efficient. Sometimes, frankly, retired judges are not the most efficient. They're not used to being as efficient in court. So you need to, the attorneys, when I say you need to, the attorneys need to set the ground rules with the arbitrator. This is what we want to do. This is how quickly we want to do it. Here's the information we agree to exchange during the arbitration. And when you work with an experienced arbitrator, you can put together ground rules that really are very cost efficient for a client. But it's not easy, like anything else in the process. It's not easy. You have to work hard to make it a cost efficient arbitration as well. The experience of the lawyers really cannot be underestimated, even the arbitration process. If you have a lawyer who thinks that they're going to present their case to an arbitrator the same way they will in court, it'll take forever. I mean, you're not streamlining the process. So when you have experienced attorneys who've worked with arbitration before, know how to streamline the process, which means, for instance, agreeing to joint exhibits so each party doesn't have to present them, and just agreeing maybe to joint facts that you both agree to. The experience of the attorneys working with the arbitrator, everybody really has to work together to make the process efficient. Same is true if you're going to court, but the same is especially true if you're going to arbitration. Arbitration cannot be forced on someone. So for instance, if one of the litigants wants to go to arbitration, the other doesn't, that's it. You can never force somebody to agree to something. And that's one of the old sayings we have here. A judge can order something, an arbitrator can order something, but two people have to agree. To go to arbitration, you have to agree. You can't be forced to do it. Arbitration clauses can end up in any agreement. Arbitration clauses can end up in prenups very easily. In fact, you can choose the venue and you can even choose the name of the arbitrator in advance in a prenup or at any other time. So that could be part of it. Would it be enforceable? It would be enforceable unless that arbitrator is no longer available for some reason. Arbitration is popular in commercial law, especially in a lot of other areas, much more so than in family law at this time. So there are arbitration associations. Quite frankly, those really don't service the matrimonial litigant well. So the lawyers are the ones who are going to find for you the arbitrator. It won't be a person going through a divorce searching for an arbitrator. That's not the way to do it, because you want a lawyer who's comfortable with the arbitrator, who's appeared before them before, who's worked with them, whether it's working with them as another lawyer, just knowing them from practicing in the field, seeing them around. But the lawyers have to have the comfort level. And quite frankly, on this type of issue, the client will need to take the word of the lawyer that the arbitrator is the right person for the job.